Okay, welcome everybody to the Vocational Science of Freedom Saturday night Civics and Sovereignty class. And tonight we'll be continuing our read from the Grand Jury Manual from San Francisco. And we've been going over this the last several Saturdays. And it is a Grand Jury Manual, Civil Grand Jury Manual from 1999 2000. It's a little bit old, but it was the only one I could find. If maybe we could find a more updated one from, and it doesn't really matter what county, and go over and see maybe how they've changed or whatnot. We could do that later. But yeah, this is a civil grand jury manual because in California they have two different grand juries in the county. They have a civil grand jury which controls the purse strings of the county's various different agencies, everything from the district attorney to the sheriff to water, utilities, whatnot. And then the second grand jury is called an indictment grand jury, which brings the true bills. And that's how they do it in California. I'm pretty sure there's a couple of states that do it that way, but at least we know that this is how California runs things. So we've been going through this grand jury manual each Saturday night for the past several nights, and we are on page 33, which is, or sorry, page 34, because we'll get into the duties, four person tempore, secretary, and publicity. And last time we covered the organization and how to get the grand jury up and running after everybody's been brought in and sworn in, and you've organized it. So duties to the poor person. Oh wait, there's one other thing that I wanted to mention. There will be another document. These are the links, by the way, that you can get to the documents. The documents will also be linked in the show notes. So whether you're watching on YouTube, Odyssey, or BitChute, the links, which will be these links, the mega Dropbox links, will link you to the documents that we'll be covering tonight, and you'll be able to take a look at them and follow along. So let's get started here. Duties of the foreperson. From the persons impaneled to serve as grand jurors, the court shall appoint a foreperson. Now, of course, if you're doing it with 25 members of the peerage and you're not going through, per se, a court, then, and you're just doing it as a secret grand jury of the common law and having the oath administered by a prothanotary or notary instead of a judge, then obviously it wouldn't be the court that would be determining who the foreperson is. And that's fine. As we've stated before, everything in the civil grand jury manual and every other grand jury manual you're ever going to find is only going to be an aspect of suggestions. There's no rules that can be placed or put onto a grand jury. And if anybody questions that, they can read USA versus Williams, which is in the Class 6 docs and links for the rest of the grand jury information, which you can find at the top of the Class 6 docs and links under National Popular Assembly on the Vocational Science of Freedom Gilded server. And you can go through all the rest of the grand jury documents that we've been covering and the important court cases that are most important for understanding grand jury's power, what the state has said about it in the past, and the fact that they have no power over it, because the grand jury is the fourth branch of government, which it's not taught like that anymore. There was a time where it used to be taught like that, but the grand jury is above government. And as I have shown in a previous class, there was a link to a video that I'd given out where there was a older retired English judge, fairly high up English judge, and yeah, I believe it's one of these, that he speaks about the Magna Carta and about the fact that the Magna Carta literally states in it that when a grand jury is formed, the grand jury basically takes over government. So, and that's how you should think about it, that there's nothing higher than the grand jury, and it literally takes over government when it forms. And as I stated before, and which you can find in the document links on the mega folder, if you pull up Corpus Juris Secundum, section 38A, it will show you that when there's a grand jury de jure, the grand jury de facto has to step down. Now, just for anybody that doesn't know, what is de jure and what is de facto? De facto means illegitimate, but in effect is basically how you want to think about that. And I posted a little infograph down in the law media, and let me click on it real quick. Oh, no, sorry, that was this is the oath. Actually, yeah, this oath that, forgive me, it's against my mind who found this the other day, but somebody brought this to my attention the other day. Um, and this was the oath that I was looking for. There is a different oath in the civil grand jury manual, but this was the one that I was looking for before. I had remembered as the one that I thought should be best one to use for when we convene our common law grand juries. So it says, "You shall diligently inquire and true presentments make of all such matters, articles, and things as shall be given to you in charge, as of all other matters and things as shall come to your own knowledge, touching this present service." Now, the king's counsel that you'd leave out, obviously. The king's counsel, your fellows, and your own, you shall keep secret. You shall present no person for hatred or malice. Neither shall you leave anyone unpresented for fear, favor, or affection. For, I don't know what that says, the writing's a little bit, for something or gain, I don't know what that says, or any hopes thereof. But in all things you shall present the truth, the whole truth, and nothing but the truth, to the best of your knowledge, so help you God. And then the American one is even a little bit slightly different than that, because obviously it doesn't have the King's Counsel part in it. But let me go back here and find I'm pretty sure that I'd put it into the docs and links, but maybe I hadn't. Oh, actually, you know what? I know exactly where the de facto part of it was. I put it into a different folder, but it's still accessible to everybody. I'll get the link again. But it was I actually put it in the VSOF online library, and okay, there it is. De facto versus de jure. This was the pictograph, or the infograph, I guess you want to call it, for de facto government. And I'll put it up in the chat so everybody can take a look at it so you can read it. So this is what de facto government is. Just de facto in general, okay? So basically de facto means illegitimate, but in effect. Kind of like how, the mob comes around and collects protection money from you because you're being protected from the mob. So that's an authority that is illegitimate, but in effect. So that's an aspect of like de facto. So it's no, not acting. It's of fact. De facto. It actually means of fact. A government of facto. A government usually existing power and control, as opposed to the true and lawful government. A government not established according to the Constitution of the nation, or not lawfully entitled to recognition or supremacy, but which has nevertheless supplanted or displaced the government de jure. A government deemed unlawful or deemed wrongful or unjust, which nevertheless receives presently habitual obedience from the bulk of the community. That's de facto. And that's what you have. That's what we have in America. You have corporate government. And if you want the totality of the whole breakdown of the history of it, go listen to the timeline class that is on, I believe I posted it on Odyssey. I wasn't going to post it on YouTube because I was sure that I was going to get another strike, because the true history of what's been going on this planet is not something that people in control want to have widely known. So it is posted on Odyssey. So if you go and listen to the timeline class on Odyssey, you'll get a far better understanding as to how we got to going from a loose affiliation of sovereign states who had just defeated the greatest power on the planet at the time, England, to the Articles of Confederation, to then the Federal Constitution, and the fact that the Federal Constitution and the United States of America is a trust between the states. And that from there, that being the de jure government, and the de jure governments on the county level would be the grand juries, and not these corporations, which all run under municipal law, also known as Roman civil law. And Roman civil law is foreign to you and to us as Americans, and always has been and always will be. If you have any question about that, just go read the cover of Bouvier's Law Dictionary, and it will explain it to you. The title of the book, simply, of Bouvier's Law Dictionary, will explain to you the fact that Roman civil law is foreign to you. So, okay, so now that that's caught up and we know the difference in de facto and de jure, Oh, well, there's one last thing I want to mention about this. In the, and you guys can look at this because it's in the, everybody can look at this because it's in the Vocational Science and Freedom Law Library. This particular folder, this de facto versus de jure folder, what I did was this treatise right here, it says a treatise on de facto, read to the end. Okay. I started making some notes in here. This treatise was stunning as to what the attorney was saying, that that de facto governments had legitimacy. It was the level of hubris in this document, in this treatise, was absolutely insane. I couldn't believe it when I was reading it. But it's taken me 25 years to find this. I've been looking for something like this for over 2 decades, and I finally found it. I never would have thought that they ever would have written a treatise on de facto government. When I did find it a while back, I was actually shocked. And I believe Hawk was the one that actually sent it to me, or at least pulled something from it. And I said, where did you get this from? And he said, yeah, it was a treatise on de facto government. I said, what? You found something like that? He said, yeah. So he sent it to me, and I've been making notes in it. Now I will be making notes and continuing to make notes in it all the way, probably all the way through until I get done with it, which might not be till the end of this year. I don't know, because I have reading time. I do research from time to time in between working on people's cases and getting people's doc sets done. So, but if you guys want to really see what's going on, it's a very, very interesting document. And yeah, it's 800 plus pages. Yeah, it's big, but it has a very good table of contents. And in the table of contents, it does eventually show you what the remedy is for a de facto government. And I'll just skip to the chase here real quick just to show everybody. And it's quo warranto. So let me blow this up a little bit because it might be difficult to see. So, and this is something else was very interesting that I found, the fact that it's all the way at the end. They finally wait to give you the solution towards the end of the book, or well, it's not the end of the book; it's kind of the middle of the book. But chapter 33, it's the 33rd chapter where they give you the solution. Yeah, that's not Masonic or anything, is it? Right? Book 6, chapter 33. This, anyway, when you start to see these things, you realize like where they come from. You can see it all the time. You can see the patterns. But anyway, the point is that you want somebody out. You want to sue out and try someone's title to office, because that's what you call it, to try title to office. You do it by quo warranto. So just keep that in mind. I have not got yet to this section of this book, but I will eventually and make the notes in it. But this is a very important aspect of connecting this, and why I'm going about this or continuing to talk about this is that it does directly tie into the reasons why we have to form grand juries. You have all of this de facto government out here, all these corporations acting as though they have any authority over you. Okay, what is the first thing we should start doing with grand juries? Demanding that they show why they have any authority. And of course they don't. But learning books like this will give you all of the ammunition that you need, as far as truth is concerned, to shut them down. If they were ever to come back with an argument, well, we're so-and-so and this is just the way things are. No, that is not the way things are. I'll read the first paragraph, or sorry, the first two paragraphs. It's just, the language is just so stunning. I just want to bring it up. Okay. Definition of the de facto doctrine. The de facto doctrine is a rule or principle of law which, in the first place, justifies the recognition of the authority of governments established and maintained by persons who have usurped the sovereign authority of the state. That is the first sentence of this treatise, just to give you an idea about where this thing's going. And assert themselves by force and arms against the lawful government. Semicolon. Secondly, which recognizes the existence of and protects from collateral attack public or private bodies corporate, which though irregularly or illegally organized, yes, that says illegally organized, yet under color of law, openly exercise the powers and functions of regularly created bodies, which is the bodies that should be doing what they should be doing, like de jure grand juries. And thirdly, which imparts validity to, and there's no validity to this, but you have to realize these are filthy attorneys writing this, okay, that want to keep their Roman civil law, New World Order bullshit, right? Which imparts validity to the official acts of persons who, under color of right or authority, hold office under the aforementioned governments or bodies, or exercise lawfully existing offices of whatever nature, in which the public or third persons are interested, where the performance of such official acts is for the benefit of the public or third persons, and not for their own personal advantage. Well, what the hell happens when it is for their own personal advantage? Which is exactly what we have out here with all these corporate courts and corporate government in general, and the Federal Reserve, right? Clearly that's for their own personal advantage. That has absolutely nothing to do with the benefit of the public or third persons. Absolutely zero. Nothing. You can't even begin to argue that. So in my notes here, I said right there is a contradiction. You hold a lawfully existing office or you don't. So to add to this sentence is intentionally misleading, which of course it is. Next note, I said this is when they were talking about public. Well, here, let me read this and then I'll read the note because it's a little bit farther down. Okay. So the doctrine is grounded upon considerations of public policy. Okay. Public policy, not public law. Public policy is everything that you have from the administration of infants and the administration of corporations. That's public policy, not public law. Public law is a harm. And public law also affects everyone. A public law is something that everyone must obey, is the whole of society, right? Because it's based on harm. Okay, public policy is not that. So think about what they're saying in this sentence. The doctrine is grounded upon considerations of public policy. Right there, it's telling you there's no reason to follow this at all. Zero, none, zip, zilch, forget it. Right? And then they throw in justice and necessity. Well, and necessity. What did they do in 33? Everything that they did in 33, they've said, well, we're doing this based on necessity. Because, now if you don't know, there's a maxim of law that says necessity knows no law. Well, if you're the one that creates the problem, and this is the Hegelian dialectic, problem, reaction, solution. So you're the one that creates the problem. The Federal Reserve creates the problem in 1913. They run up everything. They crash everything. And so that you have this emergency in 33. Right. Who created the emergency? The same damn people that you're running back to try to help you. It's insane. It's almost like Stockholm Syndrome. I mean, we in America are suffering from Stockholm Syndrome, from the Khazarian mob, literally. That's the best way I can put it. So anyway, continuing the note here, the maxim of law, necessity knows no law, was the justification of all the fraud and lies that were perpetuated upon the people during the New Deal. After the New Deal, the de facto had to rush to get everyone under contract, that's the Social Security number, to make it look like the people were agreeing to the new administration. After all, those who would enter into contract with a corporation must have to agree that the corporation that they were entering into contract with was valid and lawful in what they were doing. No? Our consent gives the de facto corporation legitimacy in their mind. Never mind that no one knew what was going on, and that all contracts that they were entering into were unlawful by design, which is exactly what's still going on. Okay, so then to get back to the paragraph here. So the doctrine is grounded upon considerations of public policy, justice, and necessity, and is designed to protect and shield from injury the community at large, or private individuals. See, that's the attorney. You hear that language? You hear, and I'm specifically speaking with a different voice to put the point across. It's hubris. They're saying, we're doing this all for you. You should be happy, right? That's what's coming across in this language. And this gets ridiculous. Who innocently or through coercion submit to, acknowledge, or invoke the authority assumed by governments. There is absolutely none of these fools that are doing this innocently, right? Which is what I said in the note. Innocently or through coercion. None of these filthy attorneys who invoke the authority assumed by government do so incorrectly. It is all done by coercion, period. So, corporate bodies, right, the corporate government, or officers above mentioned, which was everybody that was doing the de facto stuff. While this doctrine may be susceptible of improvement, Yet we think it accurately and sufficiently embodies the leading features and scope of the de facto doctrine. Singularly enough, notwithstanding the abundance of literature written upon this subject by judges and text writers, no general definition embracing the whole ground covered by the doctrine has, so far as we are aware, ever been attempted. So what does that mean? That means that this doctrine, this first paragraph that I just read to you, is the absolute definition of de facto doctrine regarding the totality of it. That's it. You can take that as the de facto doctrine and throw it in anybody's face and say, this is de facto, and you are de facto, and we don't have to tolerate it any longer. Period. Because they've said that it's never been attempted. So they just put it together. So if this is what it is, guess what? That's what you can stomp them in the face with. So my last little note here, I said, so you can give the general definition to all you present it to, because by necessity, there is no other definition. So if you want to use the necessity thing against them, you just do it with this. And anyway, I'm not going to get into the rest of this. I'll get back to the civil grand jury manual for the night. But this was so important that I'd found this, and I wanted to connect this in with why we're doing everything that we're doing here at the Vocational Science of Freedom, to teach people about their own power in grand juries. So anyway, so you guys can take a look at that, go over the de facto doctrine. I've been pulling cases out of here and adding them to the file folder. So when I find a court case, I put it into the de facto doctrine case folder. And then there's other documents regarding de facto versus de jure, which I've come across. This is a Puerto Rico case, a very, very recent Puerto Rico case. It was arguing the de facto. I'll just scroll down just to give you the points, or not the points, sorry, but the questions presented by this brief. This is a certiorari cert to the Supreme Court. So, does the de facto officer doctrine allow courts to deny meaningful relief to successful separation of powers challengers who are suffering ongoing injury, like we all are, at the hands of the unconstitutionally appointed principal officers? Question mark. Right? So anyway, this is a very interesting case. You guys can read it on your own. But this is what we're getting into, right? The understanding of how to get rid of this de facto shit. Now, of course, people in Puerto Rico, I'm sure, have had enough of the United States Federal Corporation running their lives for God knows how long, and never making them a full state. They've just controlled them through Congress ever since, because those are the cases, they were called the insular tariff cases that went through the Supreme Court while back about, and this was a while back, and where they were talking about that Congress governs everything that the United States owns, territories and the like, however they want to. They do not have to follow the Constitution, and people need to get that through their skulls. And a judge will tell you too. I've even actually heard it, and I've read it in transcripts. Someone goes into court and starts talking about their constitutional rights, and the judge will say, "Shut up! There are no constitutional rights in here." And he's right, because you've consented to be subject and under the jurisdiction of a de facto court, a de facto government, and you've done it all by contract. You've done it all by your own stupid consent, through the forms of licenses, registry of your children, and of course the whole totality of the system, which is administration of our estates through force, fraud, lies, and coercion, which is of course what we fix with the Vocational Science of Freedom status doc set, to correct that, claim your estate properly, and get rid of all the rest of the presumptions that they have over top of you. So with that, now let's get back to the grand jury manual. Duties of the foreperson. From the person impaneled to serve as grand jurors, the court shall appoint foreperson. Okay, so we talked about how we can be appointing our own foreperson. It is customary for the judge to customary, right? So they're still telling you these are just suggestions. No rules here. It is customary for the judge to appoint the foreperson after the jurors have taken the oath. Great. The court shall appoint a foreperson when the person already appointed is excused or discharged before the grand jury is dismissed. Okay, great. And again, this is under penal code, so none of this applies to de jure grand juries. The following are the usual routine duties of the foreperson. 1. To preside at meetings of the grand jury as efficiently as possible so the jury can accomplish its work. 2. To consult with the presiding judge of the Superior Court when necessary and request his appearance when desired. Notice that says Superior Court. Now, California, all courts are courts of record, constitutionally. But if you don't act like it's a court of record, it's not going to be a court of record. But technically, the definition of a superior court is automatically a court of record because you have three different types of courts in America. General categories. If you want to know about every single kind of court and every single kind of jurisdiction, then that's what the totality of law class was that we did in March, which anybody, of course, can still purchase for 3 rounds of silver. And you can then, I'll give you the private URL link, and you can download it and go through it. And I covered everything in that class. Every kind of court, every kind of jurisdiction, showed how they overlapped, showed how you got stuck into them, all of it. So that's all in that class. So I'm not going to rehash it here. But the three different kinds of courts are inferior courts, which do not proceed according to the course of the common law. They sometimes don't even keep a record, and their judgments can be collaterally attacked. A Supreme Court, and by the way, inferior courts are basically all the courts that are out here, for the exception of technically the appellate court and the Supreme Courts of the states. So you have the Supreme Courts, right? So the Supreme Courts can do original jurisdiction based upon constitutional issues, also high prerogative writs like quo warranto, mandamus, habeas corpus, and the like, all of the high prerogative writs. And then you have superior courts, and superior courts are the courts of record, which are higher and above the Supreme Court, which the Supreme Court of the United States has said before in a court case, which is in my law of the case, which you can also find in the VSOF Law Library, which I won't bring up right now. And you can go check it out and double check it for yourself. But the Supreme Court of the United States has said that a court of record whose decision is final is binding upon all the world as the decision of this court would be. It puts an end to controversy regarding the facts by deciding them, I think is how that goes. I might have butchered that a little bit, but it's in the law of the case. So, okay, so number 3. So that's Superior Court. Right, so they're saying Superior Court. So to consult with the presiding judge of the Superior Court. So the chief judge of the Superior Court of the county. Because there's only, and this is going to sound weird, but it's true, there's only one court per county. There's a lot of different divisions for the one court of the county, but there's only ever one court technically of each county. And you have a chief judge for each county. Now, what I would suggest when you form your grand juries is that you write a very well-written letter to that chief judge and you tell him exactly what you're going to be doing. And you word it in a way that's not, how should I put it? You don't want to word the letter in a way that's combative, but you do want to word the letter in a way that's forceful and backed up by authority, as in, the court cases that are on the Vocational Science and Freedom Law Library and in the grand jury folder, to show him or her that you guys are the power and that you'll be coming to him or her with matters, that you expect subpoenas to be signed, that you expect cooperation because they are your servant. They're public trustee. You could even throw and I would throw, particularly if you do live in Virginia, I would throw the original Virginia Bill of Rights of the state constitution at them. Because that one clearly says that magistrates are subordinate to the people, I believe is what it says. I think that's how it's written. But anyway, it's number 2 in the Virginia Bill of Rights in the original Virginia Constitution. Go read it. There is no question that they are saying that you guys are public servants, you're trustees, and you are under us without question. They made that abundantly clear. So, grab things like that, put it into the letter, put them in their place, but just do it correctly and do it with respect, because they are your underling. You don't want to just beat on them like you're a slave or something. They're doing it for a good reason. Just remind them what the reason is, right? And you could throw some of the de facto stuff in there too and be like, I know what the de facto part is, and that's not what we're doing here. So don't even try. You can bring it up that way. Like, don't even try to go that route with us, because we know what this is and we're not going to tolerate it anymore. In fact, that's why we're forming. So, number 3. Duties of the foreperson. Number 3, to call meetings of the grand jury and prepare an agenda for each meeting. Good. Number 4, appoint all standing and such special committees as may be ordered by the grand jury or as the foreperson may consider necessary. Now, we covered committees before, so you can just go back and listen to the last class. But and if you're listening to these consecutively, you'll already know it. But the committees can be everything from health and wellness, uh, safety, the various different things that have to do with county business, basically. So, number 5, request legal advice on behalf of the grand jury from the presiding judge or the city attorney in civil matters. And yeah, you can go back to the Superior Court judge, the chief judge of the county, and ask him questions or ask her questions and say, yeah, we're doing this, and what do you think about that? Or what's the best way to do this? Things like that, of that nature. And and then they'll feel important. Yeah, I'm not saying, well, I guess I am in a way kind of saying fluff their ego a little bit, but just avoid being, patronizing. Just do it with tact, I guess is what I'm saying. And win them over to your side, right? There's no reason to make enemies here when, one, they're your servant, and two, they're probably just as tired of the corruption as you are on some level, even if it's just on a morally conscious level, in their mind, that they know that they've been part and parcel of this corruption for such a long period of time, that there's probably some part of them that wants to fix it. And if they don't know how to fix it, well then, yeah, it's your job to teach them. It's why we're doing this. So number 6, to make changes in committee arrangements when deemed advisable with the approval of committee chairperson. That's, if a committee gets done with something and there doesn't seem to be any other business for that committee in the county, okay, then just dismiss the committee, make a new one, so on and so forth. Just get your business done. Number 7, to sign all communications of the grand jury, including all news releases. Right now, that's the aspect of the press side that we were just the publicity side, which we'll get to in a bit. But all communications. So it should say sign and the seal. I'll just put a note in here for that. The grand jury needs to have its own damn seal, just like all of you do with your own houses, right? You'll see it in every superior court. Every superior court has its own seal. So make sure the grand jury has a seal too, okay? Make it up however you want. Make it look good. You guys know how to make seals, obviously, because you guys made your own house seals anyway. So to make a seal for your grand jury. Number 8, to be the only spokesperson for the grand jury unless otherwise designated. Right, so you're not having every other member of the grand jury talking about or talking to a bunch of other people or the press about what's going on. So there's no miscommunication. So just one spokesperson per grand jury. Or you can make someone else a spokesman if you want to, meaning like, this is our press guy. So you have a foreman, and maybe they aren't that great about maybe oratory, right? And you want somebody to be able to go in front of the camera. So pick somebody that is and just make them your press man. It's no big deal. So number 9, to sign the final reports of the grand jury, as well as any and all other official reports rendered by the grand jury. Again, another note here, sign and seal. Do not forget that seal part. Number 10, present correspondence to the grand jury, meaning the things that are addressed to the grand jury. The foreperson will then read into the minutes and the meetings. Everyone, as we stated before, should make sure that you have good audio and video recording of all of the meetings. Oh, and by the way, again, speaking of audio and video recording, yes, in this modern day and age, there is absolutely no reason why everybody can't meet as a grand jury on a medium such as this. I'm not suggesting you could use Gilded, but you could, if you wanted to. You could set up a grand jury Gilded for your county, and each and every county could have its own grand jury Gilded. You could keep documents, you could keep links, you could post the links, as I do with how I organize things for the Vocational Science of Freedom, by using Mega Upload. There's Dropbox and then there's Mega Upload. Sorry, they're those are just two different cloud servers. Dropbox is less secure than Mega, which is why I use Mega, because Mega cannot be cracked into. It's based out of New Zealand, and so I would use Mega, but use whatever you want. It's up to you, your rules, your grand jury. And then organize it in a way where you can have each person chime in. You could have each person be live, because there is a live streaming feature with Gilded, which we've used in the past. So we usually do the round table on Wednesday nights through the streaming software, which is built into Gilded. So all you would have to do would be exactly what I do by using OBS, This is OBS software, and this is just a recording software. So I can stream and you can record and you can check your sound levels here, and this is how you keep track of the meeting. And so then everybody would be shown as to who they are. And if everybody had a webcam, there's no reason whatsoever in this 21st century day with all of the technology that we have that you cannot run a grand jury when everybody's sitting comfortably on their couch or on their comfy little seat with a beverage and a snack even on your computer desk. There's no reason why you can't do that. And would it be any less legitimate? Absolutely not. You do not have to be in the same physical place to hold a grand jury. And think about it. If anybody were to argue it, the vast majority of all the court hearings that have gone on in the past, since COVID, they've made everything remote. People don't go to court anymore under this pandemic bullshit. They simply just call in or video conference in. So do the same thing. Like I said, you can pick whatever medium you want to. I would avoid Skype if I were you. Skype is owned by Microsoft and is not secure. Zoom, I pretty much put Zoom in the same category. So I would use Gilded, but use whatever you feel like. I won't use Skype anymore, period. But yeah, so that's just something your grand jury can determine. In fact, you could be one of the first committees. How are we going to record this, right? So anyway, where are we at? Number 10. Okay, so number 11, administer oaths. So when you have subpoenaed people into grand jury, first thing you want to do is have them take an oath. And so the foreperson will be the one that does that for everyone that comes in as a witness. Number 12, to speak to interested groups upon request on functions of the grand jury. So what could that entail? Everything from talking to utility and infrastructure people about the purse strings, how things are going, to asking and talking to possibly former grand jury foremen about maybe a question that they might have, that the current grand jury might have about a prior report, right, that they wrote up, functions of aspects of the district attorney, anything, basically anything you can possibly think of. But I was just trying to give some suggestions here. So that's another job for the foreperson. 13, to assign investigations to the proper committee. Assign investigations. What is the power and the focus of the grand jury? To go investigate things. Hire your own private investigators. Or, as I said before, knock on the sheriff's office. Say, hey, do you have some sheriff's deputies that could use a job assignment for the next week? It's pretty powerful if a sheriff's deputy comes walking into some corporation and they say, yeah, I'm here on behalf of the grand jury, and I understand that they've sent you a subpoena for such and such documents. I require that you produce the documents. They're probably going to give them up pretty easy because there's a guy in a funny costume that everybody thinks has authority telling them to do something based upon something that very little people know anything about, but they do know it has a lot of power, meaning the grand jury. But it's like this spooky, weird thing that they don't quite know what powers it has. It's like magical, right? Well, use that to your advantage because use other people's ignorance to your advantage to just get done what you need to get done. You don't have to explain it to them. You don't have to explain anything you're doing. You're the grand jury. So anyway, 14, to keep such files as are deemed necessary. Again, as I said, that should be a private safe somewhere. Could be at somebody's house if you like, or technically you could even set up a bank vault if you wanted to, but then of course it would only be limited to going and getting that information when the bank was open. Of course, you have to go back and forth. It's easier to just keep it in some fire safe. And then as far as the files, that the rest of the files are concerned, keep them on a exterior hard drive that's encrypted. Okay, if you don't know how to do that, I know a bunch of people that can do it, but anyway, just put an encryption on it so that it's impossible for anyone else to get into it. And, make the password like 100 characters long, right? I had a friend do that with someone in a group much like Vocational Science Freedom years ago. And one day the FBI showed up and they took the drives. Then they came back the next day and they said, um, we can't get into these. And they're like, yeah, that was the point. So anyway, keep things hidden from things like unchartered, filthy New World Order groups like the FBI, because they don't have any charter to operate in this country, by the way. They're completely de facto. Number 14, to act as ex officio members of all committees, meaning that so the foreperson can basically be a part of all the committees and and an officer of all of them. So if anybody needs things to be done, or maybe the chair of the committee can't perform the duties for some reason, then the foreperson can step in and do that for a limited time. 16, to see that a master plan is made that includes scheduled visits and speakers, dates for progress reports from the committees, and the tentative timetable for submission of the committee recommendations to the grand jury as a whole for discussion and adoption of the final report. So, as we talked about before, when I was talking about the organization part of it, that you have these various different committees, and then they'll come and they'll report to the whole grand jury for discussion, and then the whole grand jury then adopts whatever measures that they feel in total by vote, and then put it into the final report. So a suggested set of deadlines could be March 1st to April 1st. The committee chairpersons and members should start finalizing the reports April 1st to May 1st. The committee chairperson should make preliminary presentations of the reports to the grand jury as a whole, May 1st to June 1st. The report should be approved for public distribution. The absolute final date for the release of any report should be June 15th, while reports can be released up to and including 30 days after discharge. It is best to have them released on or before June 15th, unless some unusual condition prevails. And again, these are all suggestions, but yeah, you get the point. Number 17, to recognize that his or her most important responsibilities relies in seeing that the grand jury as a whole and each of the committees functions efficiently and effectively. To this end, he or she should be in constant consultation with the various chairpersons and should require frequent progress reports as to the work being handled by each committee. So that's the foreperson. That's all their responsibility. So appoint someone who is highly organized, and I would also say analytical, and then help them out if they need it. Make sure that all these things get done. So to continue, to a large extent, the success of the jury will depend on the foreperson's skill in organizing and conducting meetings. Right, exactly. Like I said, better be organized. The jury must function as a body rather than as individuals. Correct. Since the jurors have diversified experience, interests, and philosophies, this is not an easy task. That's true. And I've once heard the term, this is like herding cats. You get 25 sovereigns in a room and they all know they're sovereign. Trust me, it's going to be like trying to herd cats. Okay. So the foreperson needs to be aware of that and be able to guide the cats. Whatever means is good and necessary. Buy them lunch, Come on, kitty, kitty. Let's get some stuff done, right? So anyway, it is the foreperson's responsibility to see that the splinter groups do not form nor enemies occur between jurors, right? So keep all the cats happy. The foreperson should strive to preside with tact, restraint, consideration, common sense, obviously, and a sense of humor. Also keeping open communication between himself or herself and other jurors. All good advice. So now on to foreperson pro tempore. In the case of prolonged or permanent disability of the foreperson to serve, the court should be notified. The foreperson pro temp acts as foreperson until a new foreperson has been named by the court. So you should name one as soon as you organize your grand jury, just so you have a backup, because life happens. Duties and responsibilities. See duties of the foreperson. Additional duties such as the following may be assigned to the foreperson pro temp. Assist and counsel the foreperson on matters concerning procedure, personal problems, public responsibilities, committee appointments, and morale, efficiency, and well-being of the jury. Just be a good right hand for them. Assist the foreperson in any way requested, right? Because it's going to take the two of you to get jobs done, right? Duties of the secretary, page 38. The grand juror elected as secretary assumes a vital role in the smooth operations of the jury as a whole, in addition to regular duties as a juror. The secretary does not need to have previous training in this field. The following are the usual routine duties of the secretary. 1. To call and record the roll of the grand jurors present at each meeting. 2. To read the minutes of previous meetings and make corrections if necessary. 3. To keep an accurate record of all proceedings at every grand jury meeting in the form of minutes. These minutes should show the following. And there's books on how to keep minutes. Time of convening, jurors absent at the time of convening, time absent jurors appear, exact hour and minute jurors or other persons leave the meeting when excused by the foreperson. Note it is important that the minutes show that at least a quorum is present at all times during any meeting or hearing, and the secretary should advise the foreperson if at any time the number of jurors present drops below a quorum. Oh, by the way, the quorum aspect is half of the jury members. So, number 5, to keep a list of correspondence presented by the foreperson and action taken. 6, to record all of the motions made, seconded, and voted upon, and the jury's action thereon. Note, it is not material what person moved or seconded any motions or what the specific vote was. It is only necessary to make an accurate record taken of the action. 7, to record reports formally submitted by various committees and the grand jury's action thereon. And 8, to record time of adjournment. And then 4, turn over correspondence and other documents of the grand jury to the consultant for filing at the conclusion of the term of office. So you have one person that's kind of taking the minutes, doing the thing, being the secretary, and then somebody else that is the holder of the records, the consultant. I believe they were talking about this consultant, I think, is a member of the grand jury. I don't think that they were talking about this being a county office. I don't think. But anyway, so as long as it's part of the member of the grand jury, that's fine. Okay, publicity. Here we get to do the fun stuff like press releases and whatnot. The penal code requires grand juries to keep secret most of their transactions. Each grand jury should decide on a definite policy as to what matters can and should be made public and who will be authorized to release such publicity. It is suggested that the foreperson be so authorized and that no other person shall make any statement on behalf of the grand jury. Like I said, you could have a press fella, if you like, do it that way, but it should just be one person. In each instance where publicity is released, finding a lot of typos in this, the jury should approve all news releases. Agreed. Everybody should agree as to what you should put out, and suggestions should be made as to what to possibly add or retract from said release. Care should be taken in the preparation of reports and releases to provide a clear, concise statement of the jury's position. Yes, I'll show you a release just in a minute here when we get to the bottom of this. When a news release concerns a report or recommendation to a department or agency, ample time should be allowed for the recipient to receive the material before its release to the press. Okay, unless you are trying to blindside them and freak them out, then negate that. So, but if it's somebody that you're giving a report to that you just want things done, and it's not someone you're going after, meaning that it's not someone you're trying to indict, then yeah, just be nice to them, let them see what's coming down the pipe before you put it out to the press. In each instance where publicity is released, consideration should be given to having it reviewed by the legal advisor before release. That's not a bad idea. Just somebody that understands libel and tort law is a good idea, so that you are not. It's not that the grand jury can be held for tort because they're above all that, but it's just a good thing to understand what you're doing, so that you're not releasing out things that would harm someone without having their day in court, kind of thing. Something that would be a libel. To continue, it will be well to have the release typewritten and to furnish a copy to any interested reporter, with a copy placed in the grand jury file, most definitely. Grand jurors must be on guard against undue publicity. Most matters requiring grand jury action can be successfully completed only if absolute secrecy is maintained through the inquiry. I would agree with that. And so now let's open up, and we'll leave the we'll leave the powers and juries for next time. But let's open up the report now, and in the folder, it's titled Grand Jury Report on Causes of Corruption. So the third one down from the top, and we'll take a look at this. It's 68 pages, so I'm giving you an idea about how long these reports are. So this report was in January 5th of 1910. So this is pre filthy Federal Reserve, ladies and gentlemen. So it's entitled Report on the Causes of Municipal Corruption in San Francisco as disclosed by the investigations of the Oliver Grand Jury and the prosecution of certain persons for bribery and other offenses against the state. So here we go. Chairperson, so on and so forth, committee appointed by the mayor. So the mayor actually asked to have this done. Not a bad idea. At least he was doing the right thing by cleaning up the city, right? Published by order of Board of Supervisors, City, County of San Francisco, so on and so forth. And preface, I'm not going to read this. This is just them talking about who did what, basically. But I'll read the resolution. Resolution number 1543, new series. Resolved that the Board of Supervisors hereby, I'll blow this up a little bit because it's probably a little hard to read. That resolved that the Board of Supervisors hereby express its appreciation of the arduous labors of the Committee on the Causes of Municipal Corruption and its gratitude for the valuable service it has rendered by its deliberations and recommendations. Adopted unanimously by a standing vote in Board of Supervisors, San Francisco, California, January 5th, 1910. And let's take a look at what they were doing. So with the contents, there's a letter to the mayor, earlier investigations by the Wallace Grand Jury. So what did they do? They went back and looked at the last reports, saw what was in there, and then adopted what they had done. The war between the laboring and the capitalist classes, interesting way to put that, and the development of the Schmitz-Roof machine. But think about that. The war between the laboring and capitalistic classes. This is pre Federal Reserve Act. Just think about this language, right? War between. This was serious. I mean, people knew what was up, and you know, people should still know what is up because it's still going on. It's just that the capitalistic classes have way outdone the laboring people and taken control of everything. Anyway, to continue, the failure of the Schmitz Roof ring to control the district attorney's office. Okay. So the Schmitz Roof machine must have been, that was the corruption. That was the group of corruption that they were talking about. Much like, if anybody's ever heard this term before, they call it the Chicago machine, where filthy Obama and all the rest of these morons come out of, right? They call it the Chicago machine because it's just a machine of corruption. Absolutely 100% machine of corruption. So that's clearly what they're talking about here. So failure of this machine to control the district attorney's office as shown by Langdon's raids on, I'm going to blow this up a little bit, shown by Langdon's raids on protected gambling resorts. His independence, the more significant because of the gambling spirit in San Francisco. Commencement of the investigation of Schmitz-Roof regime, the widespread of the evils which lent support to corrupt government as shown by the character of the crimes for which indictments were brought by the Oliver Grand Jury. French restaurant extortions, prize fight trust briberies, overhead trolley briberies, Parkside bribery, home telephone bribery, the Pacific telephone bribery, the gas rate bribery, and herein of the injustice of fixing rates by the Board of Supervisors. See, you want to talk about graft and de facto corruption? It's all in here. I mean, you can see this in this report. So anyway, I'm not going to cover this report in total. I just wanted to give you guys an idea of what a report looked like, and then give it to you. And it's 68 pages, so you can flip through it and take a look at about how to do a report that actually deals with indictments that they actually brought against people and said, no, you're not doing this anymore. So, and it gives a report as to what they did, how they did it, so on and so forth. And like I said, who signed the report and who was in it. And that has categories, like the war between the labor and capitalist parties, like I said. So anyway, so this is what a report looks like for taking out corrupt officials. So if anybody ever questions and says, well, how can we do this as a grand jury? Well, here's a report. Go read it. Go find more reports. I'm sure there's plenty of them out there, right? This thing goes all the way back to 1908. find as many as you can. In fact, we should make a repository of these things. And as I said before, specifically, look for, go to newspapers. Go to newspapers, search newspaper archives, go down to their archive, and a you'll find a clerk working. And what you do, and what their job is to help you find everything that you're looking for that's ever been in that newspaper. What you're looking for is the term runaway grand jury. So go to old newspapers and then butter up that archivist as much as you can. Buy them lunch, bring them cookies, I don't care. But get them to help you find the information for the main term of runaway grand juries. And what you're going to find is you're going to find a lot more things that will run in, and then find the reports for what those grand juries did. That will be your greatest pool of information, resource, and power, because once you see 25 or 30 of these reports, it's going to empower everybody in the grand jury to know exactly what they can do, and there won't be any question about it, and you guys can get things done. It's just that simple. Knowledge is power. So that's where I would start as far as looking for other reports as this. The other thing you might want to do, because I believe I did find this one, is the other thing you can do is you can go to archive.org and click in the search and look for grand jury reports. I don't know what I might find. I don't know if I've ever done this before. Let's just see what it does. Grand jury reports. Let's see if we get anything. And sometimes you got to click on the text, because sometimes you'll get a bunch of audios like this. It's a board of supervisors meeting. I mean, maybe there'll be grand jury meeting somewhere. And as you scroll down, what it'll do is it'll go fetch more results. So depending on how fast your up and down speed are for your internet. So I don't see anything here. Okay, whoops. Maybe that's San Francisco one. No. Okay, so I don't see anything here. So text is usually the better thing to pick. So pick search text contents, and then we'll click it and we'll see if we get anyone. Because I know the one that, oh, look at here. Look at that. Look at all those we got. Okay. All right. Time to do a copy and paste here. So this is what we got. So go have fun with those. So there's 1, 2, 3, 4, 5, 6. No, it's a judicial council. 6, 7. That's survey. Sorry. 7, 8, 9, 10, 11, 12, 13. Yeah, they just keep going. So all right, wonderful. So maybe we can pick, and a lot of these other ones. There are a lot of San Francisco ones. So, but anyway. So there you go. So there's a whole bunch of other reports. So if you go through these and you find ones that are on, specifically find ones that are on corruption, give me a note, like just DM me and tell me that you found one for corruption. Like it is, all you have to do is just click on one. Like I'm not saying this is one, but I just click on it and say this one was one. I don't know if it is or not, but, and then just come up here and copy and paste the URL. So just give me the URL if you find one that's on actually a corruption. This is loading a bit slow because I'm broadcasting and I'm recording at the same time. So I can't get this box out of the way. Oh, that's what it went to go looking for. Okay, that's what it was doing. It was actually looking for the word grand jury report. I just wanted to see if this was something on this. This looks like just another civil one. So, but anyway, so you get all the stuff in here about the reports of the coroner and the city attorney and the assessor and art commission and so on and so forth. But anyway, look for ones that deal with corruption, and you guys go and find them, post them in the. You can go ahead and post them in the grand jury section under reference. So go ahead and click on it. Anybody can post in here. So post the links that you find for corruption on the reports into the grand jury, please, in the reference section, and then we'll go over them and I'll take a look at them, and I'll just pull them off, I'll save them, and we'll put them into the files so that we have them for anyone else who gets to organizing the grand juries. Because obviously this keeps on going and going and going. This wasn't the bottom, because obviously if I keep scrolling down, you'll get more of them. But here, see, Times Gazette, where they mention the grand jury, stuff like reports like this. These are definitely things you want to check out to see if the grand jury really took some people to task. You'll look for stuff like this, and we'll pull clips like that, and yeah. So apparently there's, and this will just go and go and go because archive.org is enormous. It has, I think I think archive.org might very well be the biggest single repository available. I think. Don't hold me to that though. But anyway, so there we go. So with that, we'll say good for the night because we're getting about to an hour because we started a little bit late. So with that, next Saturday then we'll start into its powers, its duties with respect to governmental affairs. So we'll get to see how we start to use the grand jury in governmental affairs on the county side. So with that, I thank everybody for coming to the Vocational Science of Freedom Saturday Civics and Sovereignty class. We've been covering grand juries, and now I can turn off the recording and we can talk amongst ourselves.